What is that? What is that?
I know. It's like, and contract seems to be the only one where you're going, you look at it, you're like, I got nothing.
Yeah, like where do I start? I'm sorry. Like,
I know. Yeah. So I know it's so hard. There's so much pressure.
Yeah. It's okay. It's
all good. You'll know those 3 subjects better than most people. So.
Yeah. I'm starting to like this. Really, it's getting there. Really like
Yep.
back. But yeah.
Are you doing? Did you do okay on the multi-stage?
Yeah, I did okay. I got a 78.
That's what I got.
Yeah.
That's awesome. I mean, I'm saying it's awesome. I first got like a 54 on my first one. So, wow. 78, and yeah.
Wow. I like multis.
You're definitely there then. Huh?
I like multis. You can just fill it in.
That's good.
It's much thinking.
Yeah, you just, there is a stress.
Yeah,
I think.
I'm patient with essays.
Yeah.
Oh, time for these big cases.
All right.
All right.
I'm excited.
I forgot to bring out my briefs. Hey, Dan. You always call my bullshit. You have the printer next to you the full time.
You guys want to sign in? How come my file be corrupted? Takes care of that.
even have a whiteboard up there.
Okay. So, everybody read their assignments? Everybody brief them? Everybody confused? Not that confused, but, well, did last week help put together that reading assignment? Okay. So what you'll find in constitutional law civil procedure, when we're looking at the Supreme Court, is a development of a rule over time that may develop over a period of 50 or 100 years. So that's what we're looking at. So with international shoe, we get notions of fair play and substantial justice. And that's the statement of the rule, basically, in order for you to have minimum contacts, the exercise of jurisdiction has to comport with notions of fair play and substantial justice, right? And then the court develops that rule over time, because what does that mean? It's vague, isn't it? What are we going to call this rule? What are you going to call this rule?
Minimum contacts.
Minimum contacts rule. This is the minimum contacts rule. Okay? In order for a state to exercise personal jurisdiction over a person or a corporation or entity, they have to have minimum contacts such that they don't offend the notions of fair play and substantial justice. Well, what does that mean? Offending the notions of fair play and substantial justice or comporting with those notions. Anybody been paying attention to what's going on in Washington in the last week?
Yeah.
What have you been paying attention to?
No, I thought you were talking about Kavanaugh hearing.
Yeah. So everybody been following that? A woman out here named Dr. Ford says that he tried to rape her.
Oh yeah, I did hear about that.
You read about that? Okay. When they were teenagers, when she was 15 and he was 17 and they were at a party and he was drunk. He says it never happened. Okay. So the Republicans in the Senate set a hearing for next Monday. This came out on Sunday. So they set a hearing for the following week on Monday. Do you think that that comports with notions of fair play and substantial justice for her? Kavanaugh has been in the White House every day getting prepped to testify. Do you think a week's notice comports with notions of fair play and substantial justice? Anybody? No? Why not?
Because she doesn't have obviously the resources available that he has. They have the same amount of time, but like you said, he's been being trained to testify since the news came out, essentially.
And she's here.
Yeah.
So she's got to travel.
Travel to.
And she has a job. She's a professor. So she's got to make arrangements, and she can't go running off to some place and start getting prepped. Anybody disagree?
I do.
Yeah, what do you think?
Well, she's the one that's alleging this incident, and I see him as the defendant. So I thought the jurisdiction was based on the defendant's right.
We're not talking about jurisdiction. We're just talking about substantial notions of fair play.
Oh, okay.
And
Okay.
so we're trying to get a handle on what does that mean.
I would still argue that Trish is right though, because she is the one bringing the allegations, so she should know the story inside. She shouldn't have to be prepped to be testified. She should know the story inside and out if she's bringing these allegations.
That's a good argument. Okay. That's a good point, and you make a good point. Okay, that she's the accuser and not the accused. Let me give you a little more information. The federal rules, which are written by the Supreme Court, but they have to be passed by Congress and specifically the Senate. So the Senate should know what the rules are, right? The rule in federal court is if you want somebody to testify and you subpoena them, you got to give them 14 days notice. Okay? And it's the same in state court. You got to give them 14 days notice. And if the attorney for the witness, and it doesn't matter whether the witness is an accuser or just a third-party witness or a defendant, they all have to get 14 days notice. Okay? And if the attorney for that witness contacts the attorney who's doing the subpoenaing and says, that date, the date that you picked ain't gonna work because you didn't consult us first. And it turns out that my client has a very important meeting that day for his work and he can't miss it. Okay, so we gotta continue this to another day. Now, the attorney who issued the subpoena can say, oh no, this is fair. We gave you 2 weeks notice. You know, you need to show up. And the attorney for the witness says, look, I'm sorry. The witness cannot come on that date. The witness can show up any other day that week, but that day is no good. And the subpoenaing attorney says, no, we're going forward. And the attorney says, well, we're not going to be there. File your motion. So when a witness doesn't show up who's been subpoenaed, you file what's called a motion to compel the witness to testify. And then both parties wind up telling the judge in their filings, in the paper that they filed with the court, what happened and their arguments for their position. The losing party will get sanctioned, probably attorney's fees. What do you think a court would do under the circumstances? Who do you think the court would probably rule for on a motion to compel when the attorney called up to you, or wrote him a letter and said, hey, we can't do it on this day. Give us another, let's get together and pick a date that's mutually convenient for both sides. What do you think You know, and the attorney who issued the subpoena said, no, they're just stalling. They're just stalling. We need to get moving. We need to get this case resolved. So what do you think the court would do?
Probably let them decide on
They,
actual date.
what?
I should let them decide on actual date, so they
Couldn't decide on that, or they wouldn't decide on that. So now it's up to a court to be the adult in the room. Yeah,
I would say that they probably rule in favor of the defendant Kavanaugh because they gave the 14 days notice, and she's the one that brought the action, correct?
let's say she's the one who's suing.
She's the one who's suing them. She had the 14 days notice to testify. It was within that 14 days, and she's the one who brought the original action, so I think the court would rule in favor for the defendant
Everybody agree?
if the defendant brought a motion to compel.
I got somebody here who says no.
Didn't you say it was the witness that was saying that?
The witness saying, I can't make it that day.
I think the court will rule for the witness because that's the witness, so they will extend it to make sure that, the calendar will fit that witness in.
And it's not like the witness didn't just show up. The witness contacted the subpoenaing witness and said, this date doesn't work. You should have consulted us. And you should have worked this out with us before you issued the subpoena. But now I'm telling you, not a problem. Just give me another date. You don't even have to issue another subpoena. Okay? Just give me another date that's good for everybody. You still sticking to your guns?
No, given those facts, no.
Okay. What do you say?
No, I see your point. I understand that.
You changing your position? You're allowed to.
Yeah.
Okay, you're all right. The guy who issued the subpoena and filed this motion is gonna get slammed. The judge is gonna probably sanction him, hit him for maybe $1,500 in attorney's fees. Basically, judges don't wanna be bothered with this kind of, you know? You're big boys and girls, work it out. Work it out. And it's all we're talking about is notions of fair play. Forget the justice. What's fair? Okay, is it fair to tell somebody, whether it's by subpoena or otherwise, you got to show up on such and such a date, whether it's a week or 2 weeks, and not ask them what's good for them? Can they do it or not? Is that fair? It's fair if the person's free, right? If they can say, oh, sure, I can do that, let's do it. But if they're not, and they call you up, and they say, I can't do it this day, you should have asked. Let's pick another day. What do you do? If you're an reasonably experienced lawyer, or you have any common sense, you say, okay, my bad. Okay, you're right, I should have contacted you first. And that's, by the way, from a practice point, a practice pointer is you never set a deposition for a witness on a date that you haven't cleared with their attorney. Or what I just told you will happen. The difference is, if you have a brain in your head, you'll say, okay, give me another day. What's good for you? All right? Now, what's happening in the Senate is different because it's in the Senate. Okay, so they can do whatever the hell they want to do.
I have a question. Real quick.
Yeah.
Don't you think though that promotes, compromise is a good thing. I'm not saying it's not, both sides working together, but don't you think by not adhering to the rules, say the federal rule was 14 days, I don't know if it is or isn't, but say it was in this case, don't you think by not adhering to those rules and just saying, oh yeah, we'll set it for a later date, oh, I can't do it that day, oh, I'll accommodate you and set it for a later date, don't you think that promotes
That happen,
everything?
that'll happen, but what usually happens is, for example, a party goes into court and says, a hearing is set on a certain date. Usually it's a trial. Okay, the trial set in, and it's usually the trial date now, in Riverside, for example, is usually set maybe a year away. Okay, now, both the court and the attorneys know that that may never happen, that stuff happens. The kind of stuff that happens is somebody gets sick,
Judges go on vacation, attorneys go on vacation.
so somebody has to go on a vacation, attorney has to go on vacation, all this stuff, that stuff happens. So let's say the plaintiff shows up or makes you don't show up on the day of trial, but makes a motion to continue the trial because they're gonna have surgery at or about that time. And they have to have the surgery, it's life-threatening. And if they don't have the surgery, they'll get continued anyway because they're not gonna be around, okay? Judge is gonna, even if it wasn't for a surgery, if it's just for a vacation. I mean, vacations are almost sacrosanct in court, okay? If it's legit, you come in and you say, I've got a prearranged vacation that my wife and I have been counting on for the last, 4 years, and we finally could get it at this time, and we couldn't get it any other time. It's a cruise, okay? And they make the motion in enough time before the trial that nobody's prejudiced by it. The judge is going to grant the motion to continue. Now, if there's another trial date and the plaintiff does the same thing again, either the court's going to deny it or they're going to say, okay, I'll continue it, but I'm only going to continue it for 30 days. And by the way, don't come back with another motion to continue because there will be no further continuance. All right? But they never say no further continuances unless there's at least one continuance. And the rule of thumb in all courts, state and federal, is based on a reasonable request, a continuance will be granted, at least one. And the judges expect the lawyers to treat one another in the same manner. Does that answer your question?
Yeah, I just think.
It's not a rule, it's a practice, but it's a recognized practice that all courts and attorneys are supposed to follow.
I think that just promotes not getting things done timely. That's my just honest opinion about it. Say we have a deposition scheduled for one of my witnesses, and she can't make it on a certain day, and then we schedule for a different date, and then something else comes up, and then schedule for a different
Well,
date.
but that's what I just said. See, the difference is the witness says, I can't do it on that day. I got a conflict. I got to do it on another day. And you say, no, I'm sorry. We gave you one continuance, that's enough. Now you're fine with the judge, okay? Because in civil practice, we're supposed to be civil to one another, okay? And when I started in civil practice, which is in theory, more civil than criminal practice. Okay? Lawyer, there was a phrase that all lawyers used whenever they wrote a letter to the other side. Okay, which is, thank you for your anticipated courtesy and cooperation. Okay, that's a standard. And so everybody puts that in their letter. And if you're not courteous and you're not cooperative, you'll get slammed. A judge will slam you. Okay, and the reason for that is the courts don't want to be referees for all these piddly poop little disagreements over when are we going to have the deposition and whose office is it going to be in. Okay, they don't want to hear this stuff. Work it out. That's the answer. It's also time consuming for the courts. If everybody keeps running to the courts on these silly little disputes that they can work out themselves, okay, then you're taking up valuable court time that could be used for a trial.
Right.
All right? And that's more important to you than when somebody's deposition goes forward, as long as you ultimately get the deposition done. And you will. Okay. So does that give you an idea of what we're talking about when we talk about notions of fair play and substantial justice? Okay. All right. Well, let's get started with this reading assignment because we got a lot of cases and a lot of ideas. All right, we talked about specific jurisdiction last week. Remember? So this is just a quick review. You got a little more of that dosage of that on this reading assignment. But specific jurisdiction exists for a specific claim. You understand what we mean by a specific claim? Okay, let's say it's very common when you see a civil complaint to see not one claim, but several claims, maybe more than several claims, maybe 7 or 8 claims, maybe 10 claims. Okay, so specific jurisdiction exists for a specific claim like negligence, okay, or libel, right? So you may see all of those things in one complaint. So you have to have specific jurisdiction. Specific jurisdiction means specific jurisdiction for that one claim exists or may exist for that one claim, but it may not exist for any of the other claims. Okay, so what do you think happens if there's specific jurisdiction for one claim and there's, say, 2 other claims and there isn't specific jurisdiction for it? And this is a specific jurisdiction case, not a general jurisdiction case, which we'll talk about later. So what happens to the 2 claims for which there's no specific jurisdiction?
Get thrown out.
Yeah, they're gone. They're gone. So the court will exercise jurisdiction for that one claim, but not for others. Okay? Whereas in a general jurisdiction case, the court has jurisdiction over all the claims. Okay? A state has power over an individual or a corporation that has committed certain acts directed at a state. But it extends only to claims arising out of those acts. That's specific jurisdiction. Does everybody get that? We talked about that last week. Okay? The Supreme Court assumes jurisdiction is proper for claims related to the forum contacts that satisfy purposeful availment requirements. This is a quote from Ezel. The more closely related the contacts and the facts giving rise to the claim, the more likely the court is to uphold specific jurisdiction. Now, the background to the cases that we're going to be reading in this section start with a case called Perkins versus Bengay or Benguet Consolidated Mining. Okay? It's cited in a lot of the cases that we're reading, but it isn't in your book. It used to be, but it isn't now. Okay? So I'm going to tell you about it. And by the way, this one pops up in like the bar exam. You'll see facts almost identical to it. In a personal jurisdiction case. So we gotta, in my view, you gotta read this case or at least know about it. The site on it is 342 U.S. 437. That's a 1952 case. Again, 342 U.S. 437. In this case, a Philippine corporation was unable to operate due to the Japanese occupation of the Philippines during World War II. Okay? So the president of the corporation maintained an office in Ohio as the substitute headquarters for the corporation until hopefully the occupation would end. The court held on an issue of personal jurisdiction in that case that the defendant corporation, the Philippine corporation, functioned as carrying on in Ohio continuous and systematic, but limited part of its general business in Ohio and specific jurisdiction was upheld. Okay? So remember, in international shoe, we also have the concept of continuous and systematic contact, okay, or carrying out business in a systematic, continuous and systematic manner. Oh, I got a new eraser, sorry. Right, so that's the background for worldwide Volkswagen versus Woods. Anybody here drive an Audi? Anybody want to drive an Audi?
Parts are expensive.
Huh?
The parts are really expensive.
I had two Audis. The first one was the first year Audi made a car. For worldwide distribution was in 1970. That car was a disaster. It was beautiful. It looked great. It drove great when it drove. It was so bad. A friend of mine had the same car, same model. It was so bad, and they needed so much work that a guy who wanted to open up an Audi repair shop told us, made a deal with us that if we co-signed on his note to open up the shop, he would work on our cars for the life of the car for free. And we got the better part of that deal. At least 2 transmissions, two engine rebuilds. Okay. I kept it for 10 years because I had this guy that worked on it for free. And then the second one was just the car of my dreams at the time. It was, I think it was Road and Track said it was the best production car made in the world. And it was a turbo, and it was really fast, and it looked great, and it drove great. And then it developed this little quirk. After I had it about 3 years, you'd be driving down the freeway at about 65 miles an hour, and it would just stop.
That's more than a little quirk.
Yeah. Needless to say, I'm not a fan of Audi. They say that they've worked out all the bugs now, and they're great cars, but I'm driving Japanese cars now. Anyway, so worldwide Volkswagen versus Woodson. You look like you'd like to do this, Dave. Okay. So tell us about worldwide Volkswagen versus Woodson.
Okay. So the plaintiff, worldwide Volkswagen, and also Seaway Volkswagen, and among others, is an auto sales company incorporated and had its business office in New York. The defendant, Charles Woodson, was a presiding judge in the Supreme Court of Oklahoma that ruled against the writ of prohibition, denying the personal jurisdiction over them. So, going back to the facts.
What would you state the facts you just said again?
So the plaintiff is a worldwide Volkswagen corporation, and they were incorporated and was doing business in New York.
Yeah. Well, what kind of business?
Manufacturing auto.
Worldwide Volkswagen was manufacturing cars?
Sales. What are they like here? And they're involved in auto sales. They were auto sales companies.
Distribution.
Yes.
You know what a distributor does?
They just sell it.
No. Well, yeah, sort of. All right, so you got an auto manufacturer.
Yeah.
Okay. You know who manufactures Audi? Volkswagen. Yeah. Worldwide. Yeah. So Volkswagen manufactures Audi. Once they're manufactured, they have to be distributed. So they're separate corporations that do the distribution. And they distribute the cars to dealers. Okay? Dealers, mostly in the United States, are not owned by the manufacturers or the distributors, but they have deals, contractual deals with the manufacturer or the distributor, depending on how it works, okay? And so the distributor gets the cars from the manufacturer, and then they distribute them. They give them X number of cars for them to sell to the public, okay? So when you go to a Toyota dealer in Cathedral City, and there are X number of Toyotas there, they got those from a distributor. All right, and they only get a certain number every month. Okay? So that's what Worldwide Volkswagen did. It's a New York corporation that distributes Audis to dealers in New York. And in this case, I think it's just to a certain part of New York.
The dealer here was a Seaway Volkswagen.
The dealer was
Yeah.
Seaway.
Yeah.
Right. Okay.
So the facts of the case provide that Harry and Kay Robinson, they were the plaintiffs of that former case. They purchased a new Audi from Seaway in Manhattan, New York. And so the following year, the Robinsons decided to move to Arizona, and while passing through Oklahoma, they were rear-ended, and the vehicle severely burned Kay Robinson and their
The
children.
gas tank, they exploded.
Yes, exploded.
So, and Mrs. Robinson
And children.
was severely burned.
Right.
So she sued who?
She sues Worldwide Volkswagen for products liability action in the District Court of Creek County, Oklahoma. And so Worldwide and COA made a special appearance claiming that Oklahoma's exercise of jurisdiction would offend their rights established under the due process clause.
That's correct. There were 4 defendants.
Yeah, so COA.
Who were they?
Worldwide Volkswagen, Seaway, it was, oh my gosh, Audi, NSU, Audi, Auto Union, Audi, no.
Audi.
I guess that's how you say it.
I got it wrong. Audi's the manufacturer. And Volkswagen of America is the national distributor. So what that means is Audi manufactures a car, let's say in Germany. Okay, if they don't have factories here. They then ship the car, however it is, by truck or boat, to Volkswagen of America, who then distributes it to Worldwide Volkswagen. Worldwide Volkswagen. Okay, so you got 2 different distributors in the chain. Okay, but what's really important is that, never mind, we'll get there. We'll get there. Okay, so you got the chain now?
Yes.
Right, so those are the 4 defendants. All right, so what's the issue?
Issue is, they are, established that, minimum context was not satisfied in Oklahoma. So then that's why they sought a writ of prohibition with the Supreme Court, and of course they were denied.
What?
They were denied that writ of prohibition for Oklahoma to establish jurisdiction.
Okay. The issue is,
There's no,
repeat,
they didn't.
what's the issue?
Okay, so the issue is foreseeability alone sufficient to authorize the state court to assert personal jurisdiction over a non-resident defendant that has no contacts, ties, or relations with the state?
Right.
So that's,
Okay.
that's what you.
Now, what's the rule? What did the court rule on that issue?
They fell back onto international shoe regarding minimum contacts, and they need to establish personal jurisdiction, or in order to establish personal jurisdiction of a non-resident defendant.
Why?
Why?
Yeah. Why was there no personal jurisdiction under international shoe?
On what they, okay, so they applied it, well, firstly, they said that foreseeability wasn't a valid basis to establish personal jurisdiction. Just because
That's good.
they released a product or this automobile industry in commerce, they can't have foreseen that it would travel in different or long distances away from their place of business.
Okay,
So, and then
you just used two words a minute ago.
continuous and systematic.
Purposeful availment,
Okay.
right? Did you say something about purposeful availment?
I don't know. I don't think so.
Oh,
But I was about to get to it.
I guess I did.
Well, they said for in terms of minimum
Read.
contracts.
Can you point to us what the rule of this case is? What's the specific rule or basis upon which it ruled, that the court ruled?
Well, the basis was that there was no minimum contacts, nor did they have,
Why?
the only,
See, this is what I'm talking about, okay? Saying there's no minimum contacts isn't enough.
Right.
If you say that on a test, okay, that isn't gonna be enough. You gotta go further and you gotta talk about, these are the different tests that they use.
Right.
Okay? Is it continuous and systematic? Did they have any continuous and systematic contacts with the state?
they said they had
None.
no activity whatsoever.
None.
Right.
Okay, so the only other basis that one can think of, at least for now,
Purposeful.
is purposeful availment. We saw purposeful availment in a case last week. Remember?
Generally.
An insurance policy out of Texas.
Oh, yeah, the distribution.
Remember that? There were some other ones too.
Yeah.
There was the trust in the trust in, was it Delaware?
Right.
Right? And the lawsuit in Florida? Okay,
So,
so,
in regards to purposeful development, this is the only activity in Oklahoma was a single isolated event. So, given the fact that they were just traveling through Oklahoma, there's
right, so
really no basis for it.
you don't have anything there about what the court said on why there are no minimum contacts?
It's just because they didn't have no business activity in Oklahoma.
Okay, the court, thank you. Good try. You kind of got it right. Okay, but you gotta get more than just, this is what the court did. You gotta state the rule of law that the court used, okay, to get to where they got. All right, the court said a defendant purposefully avails himself of the privilege of conducting activities within the forum state when the defendant's conduct and connection with the forum state are such that he should reasonably anticipate being hailed into court. Okay? So now we got remember we talked about being hailed, like hailing a cab?
Right.
All right. So the court said that both Worldwide Volkswagen and Seaway, who sold the car to them in New York, had no business contacts with Oklahoma at all, which means they didn't advertise in Oklahoma, right? They didn't do any business with anybody in Oklahoma. They didn't have anything to do with Oklahoma, but those two were the petitioners in this case. to get a court to throw it out. But the other two, Audi and Volkswagen of America, weren't. So what do you think that means? Anybody? Those two didn't challenge jurisdiction. Why do you think they didn't challenge jurisdiction? We're talking about Audi, who manufactures these cars throughout the world, and Volkswagen of America, who distributes them throughout the United States.
They can't argue for, against continuous and systematic.
Well, you think that that Audi, who manufactures the cars and distributes or ships them to Volkswagen of America, who, by the way, are all owned by Volkswagen. But, all right. And then Volkswagen of America distributes them throughout the United States. What's Oklahoma? A state. They distribute. You think that perhaps there are Audi dealers in Oklahoma? What? You think that there's any state in the United States that doesn't have an Audi dealer? They even have them in Alaska. Okay? There are Audi dealers in Oklahoma. So, if Audi manufactures the cars and distributes them to Volkswagen of America, who distributes them to dealers in, let's say, Oklahoma City and I don't know the other places in Oklahoma. I've never been to Oklahoma. But okay, the big cities in Oklahoma, and there are a few. And there's lots of rich guys in Oklahoma, you know, there's lots of oil wells. Okay, so does that establish continuous and systematic contacts with Oklahoma? That establish purposeful availment, such as they can anticipate being hailed into court? So they didn't make the motion because they know they lose. Okay? Got it? So the guys that got out didn't have anything to do with Oklahoma. That's the test. I mean, the easiest thing to do in thinking about this, you got to go through all of these steps. But while you're reading the exam question, the easiest thing to do is, does this guy have anything to do with this state? Or does this company have anything to do with this state? Because if it didn't, the answer is probably going to be no jurisdiction. But then you have to go through that analysis and not just say, this guy didn't have anything to do with this state. I ain't going to cut it. Okay. Another case on page 112 in note 3 is an important case that you should know about and keep in mind. This is Burger King versus Rudesowitz, a 1985 case. So now we're starting to get more contemporary. The facts of this case, the plaintiff was Burger King, who is a Florida corporation. And the defendant is Rudesowitz and his partner, who are both Michigan residents. The defendants contacted Burger King to purchase a Michigan franchise from Burger King. they signed a contract with Burger King for the Michigan franchise. Once they got the franchise, they went to Florida and trained with Burger King on how to run the franchise. Like when you go into a Burger King and everything looks the same as every other Burger King, and they give you the same fast food that you get at every other Burger King, that's because they've all been trained in Florida by Burger King to do it that way. Okay? And that's what they did. Unfortunately, well, what the terms of the contract that they signed deemed the contract to have been made in Florida. And it also stated in the contract that the law of Florida shall govern the interpretation of this contract. These are not unusual terms, right? Okay. The defendants didn't make a go of it. They stopped making their payments to Burger King for the franchise. So Burger King sued them for breach of contract. And they sued them in Florida. Okay, in Florida State Court. The issue is that Florida have jurisdiction over the defendants. What do you guys think? Let's review the contacts. Remember, this is what you're going to do when you have an exam. You look at all the contacts, and then you argue it. Because unless you recognize the facts as being from a case and you know what the outcome was, okay, you're going to have to take your best shot. All right? So the first thing you do is you review the contacts. Are these contacts minimum contacts such that they do not offend the notions of fair play and substantial justice? Were those contacts continuous and systematic? Was there purposeful availment? And could they anticipate being hailed into court, Florida? Okay, so first, were these contacts continuous and systematic?
No,
No? Why no?
because they only went down there for the one training.
Well, but they had to pay on, they had to pay,
That's true.
okay? They had to pay on a monthly basis
Payments to Florida, okay.
to Florida,
Yeah,
okay?
okay.
And they probably got a bill, okay? So they trained with them, okay? They had to pay on the they had to pay on their franchise. There wouldn't be a lawsuit if they weren't making payments, because they stopped paying, okay? So we got both, we got continuous and systematic. Now, what about purposeful availment?
Yeah,
Okay, was there purposeful availment? Why?
because the contract stated that Florida rule governs, so then.
Well, that's anticipate being hailed. Yes, that's right. That's good. Okay, and Florida law will govern? Yeah, you can anticipate that you're gonna be sued in Florida and specifically in Florida because the contract says, right, deemed to have been made in Florida and Florida law will govern. So where are you gonna get sued? Right?
I have a question. So
Yeah.
is this, like an elemental rule in the sense that all elements have to be met in order for there to be
Yeah.
personal jurisdiction?
Yeah.
Okay. So if one is missed.
Okay, but let's get into the weeds later. I mean, theoretically, you could probably get personal jurisdiction if your contacts weren't continuous and systematic, but there was purposeful availment, and you could anticipate being hailed.
Because I would think just that one provision in the contract that says that Florida law governs, them agreeing to that and signing to that would be enough for Florida to have jurisdiction.
No.
No.
No, you gotta have contacts. Okay, you gotta go through this whole thing. Okay? That would be one factor. That in itself is not a contact. That's a purposeful availment anticipating being hailed factor to establish minimum contacts.
Interesting.
Okay? Yeah, it's very philosophical.
But it's like, what's the point of the clause then, you know, why do you even have that contract to fulfill one?
For exactly that, for both that reason, so that they can sue them in Florida. Because
Well,
Burger
potentially-
King doesn't want, listen, you've got a big business like Burger King, that's international, right? And you're gonna have problems with your franchisees all over the country, all over the world. Okay? So you don't wanna be paying lawyers all over the country to sue these guys. That's why you have that clause. That's number one. You want it in Florida, okay? That's number one. Number two, you don't want some other state's laws governing it, because some states have laws that aren't favorable to corporations like Burger King. So they obviously, one of the reasons they are doing business or their headquarters in Florida is they like Florida law. Okay? They're not in California, which isn't as favorable to corporations as Florida is.
Yeah, I understand why you would have it in there, but
Okay.
I think it's just it's odd because it just plays as one factor in determining whether or not they have jurisdiction. But the clause will say that the laws of Florida govern this contract when they really don't. They just play like one little factor. They could potentially.
You could put in the contract that all lawsuits will be in Florida and that Florida has personal jurisdiction. You can do that. That doesn't mean that they will.
Right, that's what I'm saying. That's
Okay.
why I think it's crazy.
That doesn't mean that they will,
Yeah,
but certainly if you have that in your contract, that goes a long way towards showing that you can anticipate being hailed, right? So you got at least one thing going for you there. And then if you could come up with some other factors, then you're home free.
just blew
All
my
right.
mind.
Got it?
My mind is blown.
And we've only done one case.
But then, Professor Moyer.
Wait a minute. He's got to pick
Oh, I'm
up
sorry.
with his brain. What?
No, I was gonna say, but then, you know, kind of piggybacking what, Daniel is saying, you could basically call it an unconscionable contract based on unequal, bargaining powers.
No, don't get involved in contract law. Stick with personal jurisdiction, okay? Only contracts have to do with personal jurisdiction is that you can anticipate being hailed by virtue of that contract, right? If there's nothing in the contract about it, then that doesn't mean that the contract may not be important, because if both of the parties entered into the contract in the forum state, that's certainly a contact that would indicate that it may be a contact that would go towards minimum contacts, all right? You made the contract in the foreign state. That's kind of an important fact. Okay. Now, in this case, the rule of the case was the opinion was written by Justice Brennan, who was another giant. He wrote, by reaching out to Burger King for a franchise and entering into a contract with a corporation based in Florida, in a contract governed by Florida law, and training in Florida, defendants purposely availed themselves of Florida. What's important about this case is we got some new language here. Plaintiffs reached out to Florida. Okay? You get, that's that, and reaching out that's helpful, isn't it? In analyzing this stuff? Isn't that what happened with the insurance policy from Texas to California? They reached out to California. Okay, so now we got reaching out. And this gets us to we already got the being hailed and all that stuff. So by the way, Brennan talks about reasonable notice of being hailed in the court. Remember, notice is a concept, a real important concept in due process. So if there's something about this deal that we're talking about that would give somebody reasonable notice of being hailed in the court, that's going to give you purposeful availment. Okay? Now that we have all these concepts in play, why don't we talk about McIntyre Machinery versus McCastro? Is there somebody who really likes this case? This is the guy who got his hand injured using a machine manufactured in New Jersey. He got hurt in New Jersey, and the machine was manufactured in the UK. You've already done your thing.
I can try it.
Okay, go for it.
So, this is a products liability suit filed in New Jersey. And a Robert Nicastro seriously injured his hand while using a metal shearing machine that was manufactured by J. McIntyre Machinery. And so the accident occurred in New Jersey, but the machine was manufactured in England.
And where's McIntyre incorporated and operating?
They also are in England.
Yeah.
So that's so I have as the issue is whether the New Jersey courts have jurisdiction over McIntyre. It says notwithstanding the facts that the company had no.
Whoa. You got the facts right so far, but you left some stuff out.
I left some stuff out.
Contacts. Did remember, in looking and briefing these cases on jurisdiction, you got to look at the facts that are necessary or factors that are necessary to establish jurisdiction. In the case of personal jurisdiction, it's contacts, minimum contacts. So going through the minimum contact analysis here, or the questions to ask is, did McIntyre advertise in New Jersey?
I didn't see where it would advertise.
It
I saw
didn't.
that it did,
It
okay.
did not. So McIntyre didn't advertise in New Jersey. Did it send goods to New Jersey?
It said, yeah, it said that it agreed to sell. Let's see, an independent company agreed to sell McIntyre machines in the United States.
Didn't say New Jersey.
It didn't say New Jersey, right?
Okay. It sold its machine, McIntyre sold its machines to an independent company,
Okay.
okay?
Okay.
And it doesn't tell us where this independent company is, but it's not in New Jersey. So we don't have McIntyre sending any of its machines directly to New Jersey,
Right.
okay?
They
Did it in any way target New Jersey?
No,
Okay,
no.
all right.
So, and it, they also state, well, they said that their arguments were that they had annual conventions, but not in New Jersey. So
Right.
that was-
Okay, so there was jurisdiction was challenged in New Jersey. What did the New Jersey state court rule?
The state court rules,
Did it find jurisdiction? You don't have that in your brief?
I think it did, find no, it did not find jurisdiction.
It did,
It did? Okay, because it said that the.
because 4 machines wound up in New Jersey. Doesn't say how. This machine wound up in New Jersey, so it says defendant's machines were sold in New Jersey.
Uh-huh.
So because the machines were sold in New Jersey, McIntyre, the New Jersey has jurisdiction over McIntyre. Now the question is, in the Supreme Court of the United States, does New Jersey have personal jurisdiction over a company that doesn't advertise in New Jersey, doesn't send goods to New Jersey, and in no way targets New Jersey? That's the issue. What's the ruling of the court?
The ruling of the court is, I had here that they reversed the judgment from the New Jersey Supreme. And,
So they found personal jurisdiction.
well, it says that defendant does not have a single contact with New Jersey, short of the machine in question, and be nothing in the state. So it says that it reveals an intent to serve the U.S.
Where's your brief?
So I have it on here.
You didn't?
I didn't write it out. I
You-
book briefed
You
it.
gotta write it out,
Okay,
okay? Book briefing's a no-go.
okay.
All right, at any rate, do you have the rule of the case?
I wrote the rule as, I found it as, they put as a general rule. The exercise of judicial power is not lawful unless the defendant purposely avails itself of the privilege of conducting activities within the foreign state, thus invoking the benefit and protections of its laws.
That's that one.
Right there.
purposeful availment, okay? All right. That's sort of right.
Sort of right.
The issue of the case, amongst other things, was that New Jersey and the plaintiff based the notion of personal jurisdiction in New Jersey on the fact that McIntyre placed the machine in the stream of commerce. The stream of commerce concept is one of constitutional law. Okay, that's the basis for the federal government regulating commerce and lots of things throughout the United States. Okay. The Obamacare was based upon the drafters of Obamacare argued that that regulating healthcare throughout the insurance throughout the United States, okay, was a regulation of commerce through the Commerce Clause, okay, because insurance is throughout the United States. It's obviously there's commerce throughout the United States. There's a stream of commerce. The Supreme Court said in that case, no, but it's a tax, and it's a regulation through the government's power to tax. But that's an example of the Commerce Clause and the notion of stream of commerce. The court in this case said placement of a product into the stream of commerce without more is not an act of the defendant purposefully directed toward the forum state. And it cited a case called Asahi versus Superior Court, which was a 1987 case. Asahi was a plurality decision. And this opinion by Justice Kennedy, who I would argue is also a giant, he's resigning as of, or he just resigned as of July. That's what this kerfuffle is about appointing a new Supreme Court justice. It's his seat. Kennedy wrote, in product liability cases, the transmission of goods permits the exercise of jurisdiction only where the defendant can be said to have targeted the forum. As a general rule, it is not enough that the defendant might have predicted that its goods will reach the forum state. This court's precedents make clear that it is the defendant's actions, not his expectations, that empower a state's courts to subject him to judgment. Well, I'd argue with him on anticipating being hailed into court, but short of that, he's saying your expectations that you might get sued by just placing something in the stream of commerce isn't enough. You have to have targeted the state in which the person who is suing files the lawsuit. Okay? So what do you think would have happened if the US distributor was a wholly owned distributor of McIntyre? Would that make a difference? Trish, did you say something?
I would say that it would make a difference. I
Why?
didn't say anything. Oh, because the connection is closer.
The distributor, the independent distributor that McIntyre sold its machines, who then went on to sell machines in New Jersey, okay? Assume it's no longer independent, that it's McIntyre's wholly owned subsidiary. What, does that make a difference? You said yes. Now, the question is why? It owns it. Okay. And its wholly owned subsidiary, is it targeting New Jersey? But say, we don't know anything about advertising, but it's selling machines in New Jersey. We know that much. Is that targeting? Is that enough to establish targeting?
Well, they sold swarm machines, didn't they?
Huh?
They sold swarm machines for the day, didn't they? So I would say yes.
Okay. So what if, maybe it is, maybe it isn't. It's certainly a contact, right? Isn't that a factor that would go against McIntyre? Okay, so we know that it's got a wholly owned subsidiary that's selling or sending a machine to New Jersey. Maybe that's not enough. Maybe you need more. What if McIntyre advertised and sold directly to New Jersey retailers? That's targeted for sure. The other one, probably a factor. In other words, that could go either way. And on an exam, that's what you should, where you got something that's shady, right? If you're looking at it and you just can't really say one way or another, then you say, that's the one you say. It could go either way. Court could rule this way because it could find that there's targeting, but a court could rule no, there's no targeting. And then okay? You get all the points. Okay. What if Nicastro sued in federal court? There's dictum in the case that says, remember what I said about dictum? It's not a rule, but it's something you look at to get a direction on what the court might do. In this case, petitioner directed marketing and sales efforts at the United States. It may be that Congress could authorize the exercise of jurisdiction in appropriate courts. That circumstance is not presented here. Okay? So, absent Congress saying that putting something in the stream of commerce or directing marketing and sales efforts at the United States establishes personal jurisdiction, we're stuck with these rules. Okay? Yeah, we don't have any laws that say. Well, let's go on to internet cases. I'll do one case. I'll do two cases. And then we'll take a break. On these internet cases, y'all look at Zippo Manufacturer versus Zippo.com. In 1997 case, see, now we're getting close. This is on page 125 and 127 through 128. Zippo Manufacturing, a manufacturer of cigarette lighters, everybody knows what a Zippo is, right? Sued Zippo.com, an out-of-state news service in Pennsylvania State Court for federal trademark violations. Probably using the name Zippo. Okay? In this case, the court adopted what is called or referred to on page 128 as a sliding scale test. All right? It says, and this is something that you should be memorizing if you get an internet case. Okay? The sliding scale test creates 3 different types of websites. Concept of 3 different kinds of websites. There's an active website where the defendant clearly does business over the internet, where the defendant enters into contracts with residents of other states that involve knowing and repeated transmission of computer files over the internet. In those cases, there's jurisdiction. That's continuous and systematic, is it not? Okay. There are passive websites where the website does little more than make information available to those who are interested in it, like Wikipedia. That's a passive website. You don't buy anything from Wikipedia, do you? Do you get any emails soliciting you to donate money to Wikipedia or to enter into some kind of a subscription with Wikipedia?
Now they ask for donations.
They ask for donations, but that's it. Yeah, you think that's enough?
No.
Yeah, it's passive. There's no jurisdiction there. Then you got what will probably be the issue on any test. That's an interactive website, which is the middle ground. Here, a user can exchange information with the host computer. In these cases, the exercise of jurisdiction is determined by examining the level of interactivity and commercial nature of the exchange that occurs on the website. Here, Zippo.com was a highly interactive website, and more important, the trademark infringement claims were related to the business context with its Pennsylvania customers. Okay, so you guys got the sliding scale down?
What was the first one called?
That's an active website.
Active, okay.
That's the one where there's jurisdiction.
Where they're just clearly doing it.
Yeah, this is what it is. This is Amazon. But, the defendant enters into contracts with residents of other states that involve knowing or repeated transmission of computer files. You go on Amazon and you buy something, isn't that a contract? Yeah. Yeah, and they clearly advertising. They got all this stuff for sale. Right? Okay, Amazon's an active website. Can anybody think of what passive would be Wikipedia. What's an interactive website?
Right, with games, casino, online casino games.
Might be computer game, yeah. Maybe.
Like when you're buying something,
When
you're buying something.
Well, we just did that. Amazon's interactive. But
Would it be like online forums where you can post your opinions to the website for other people to read? You know, say like if I have an issue where I want to fix my Audi car and I don't know how to do it, and I go into an Audi forum where other people who are fixing Audi cars, somebody who's had a
All
similar
right, that's
problem.
clearly interactivity,
Yeah.
right? So then we got, yeah, so then we gotta just, then you have to determine the level of interactivity and commercial nature of the exchange. That's not in a commercial nature of the exchange.
I was just fixing.
But what about, I don't know, here's one. I get this, it's called a DP review, digital photography review, right? And it basically, it reviews all the new cameras that are out and lenses and things like that. And underneath the reviews, there are ads for Amazon or whoever, you know, another retailer who's selling these cameras with a price and lists the price for each one. That's a commercial nature. So then that's interactive. But the question is, how interactive is it? Okay, is enough interactivity if you're just reading a review? I got one. I am taking ukulele lessons online. Don't laugh. It's
No, I think it's great.
It's a wonderful instrument, man. You should hear some of this. Okay? Anyway, I mean, you could play jazz, right? There are guys who are playing rock on it. I mean, there's all kinds. Anyway, so this site has beginner, intermediate, advanced, private lessons. Okay? And you have a different choice of how you want to do it. You can pay by the lesson. You can pay for by the month. Okay, that's interactivity. You know, you hit lesson 1 and you're sitting there and you're doing this whole thing, and there are other ones where they have live lessons, so I guess you're doing it through Skype. I don't think I'm advanced enough to merit something like that. But you know, you're doing lessons on Skype. That's clearly interactive. And then they have live, you know, once a week they have a live jam, which means basically we're doing what we're doing with you, you know, all these people are playing their ukuleles and the guy who's leading the thing is talking to them, telling them what to do and answering questions. That's you know, that's interactive, and that certainly would qualify. All right, real quick, and then we'll take a break. The next case is on page 129. That's Calder versus Jones, a 1984 case. Everybody know who Shirley Jones is? You know who Shirley Jones is?
I do.
Yeah, of course you do. What was the TV
I'm
show?
old enough.
Partridge Family.
Okay, Partridge Family. Okay, anyway. Wasn't she in a couple of Broadway show movies?
Yes, she was in Broadway shows.
Yeah.
Oklahoma. She was in
Oklahoma.
I think.
Okay, so anyway, she was a big star. She's still a little long in the tooth. But anyway, she was very well known. 2 Florida residents published an article in the National Enquirer about Shirley Jones, a well-known actress who lived and worked in California. Obviously, it wasn't favorable. Needless to say, it wouldn't wind up in the National Enquirer unless there was some gossip about her. And Jones sued them in California State Court. In that court, the court articulated something called the effects test, in which the court ruled defendants must reasonably anticipate being hailed into court in the forum state. We already know that one, but we could call that the effects test. I don't have room. That's what they refer to as the effects test, meaning what effect did it have, whatever the business transaction was, or acts by the defendant, what effect did it have in the state, the forum state. The court wrote, a defendant's tortious acts can serve as a source of personal jurisdiction only whether the plaintiff makes a prima facie showing that the defendant's acts were intentional. Now we're talking about torts, okay? This is not a contract case. Were uniquely or expressly aimed at the forum state. So aimed at the forum state is targeting, right? And caused harm, the brunt of which was suffered and which the defendant knew was likely to be suffered in the forum state. So in these cases, you have to show not only anticipating being hailed into the forum state, but that the defendant's acts were intentional, and that they caused harm in the forum state, which the defendant knew was likely to be suffered in that state. In this case, Jones sued for an intentional tort, libel. The defendants allegedly wrote and edited an article they knew would have a devastating effect in plaintiff on Shirley Jones in California. She lived in California. Defendants allegedly knew that the brunt of that injury would be felt by Jones in California, where she lived and worked, and the National Enquirer had its largest circulation. Okay? So do you guys understand what's referred to as the effects test in an intentional tort or in a tort? Next, that sets us up for Abdouche versus Lopez. Anybody have a special place in their heart for this case? Going once, going twice?
I'll do it.
Okay.
So we taking a break first, or we?
Yeah, we're gonna take a break. All right, that leaves Goodyear versus Brown. You want to do that?
I'll do that one. I'll do the
Okay.
Goodyear one.
Huh?
I'll do Goodyear.
Okay, you do Goodyear. Well, then that leaves us with Isabel. I guess you're gonna get Dangler. Do you know anything about the dirty war? No, it's okay, I'll tell you all about it. If you go to Buenos Aires, you find it all about it. All right, then. Take a break. What are you doing now?
What am I doing?
Yeah. Doing one of the cases, I forget.
Oh, no,
You're not?
I did the other one.
Oh, you did one? Okay.
It's.
I'm doing Daimler.
You're doing
No,
Daimler?
Daniel's next.
Daniel said he'll do.
Okay.
Daniel's next.
Daniel's next, okay. 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 So, I gave you the prequel to douche. Go for it.
All right, so Helen Abdouche was the secretary of the Nebraska presidential campaign of John F. Kennedy in 1960. Richard Yates gave Abdouche a copy of his book Revolutionary Road in 1963 with the inscription, "For Helen Abdouche, with admiration and best wishes, Dick Yates." The book was eventually stolen. So Ken Lopez, the defendant, through his company, Ken Lopez Bookseller, purchased the book in 2009 from a seller in Georgia. So Lopez and KLB, which is his book company, then sold the book the same year to a buyer outside Nebraska. KLB buys and sells rare books, and they sell them through catalogs on a website. So KLB advertised the Yates book and designated it on their website as sold. KLB attends various book fairs, but they have not attended any book fairs in Nebraska. And then only 2 of approximately 1,000 individuals on KLB's active mailing list live in Nebraska. KLB wasn't registered to do business in Nebraska and did not own or lease any real estate in Nebraska. KLB didn't advertise in any Nebraska publications and had sold less than $615 in books to Nebraska residents from 2009 to 2011. And during that time, from 2009 to 2011, their total sales were $3.9 million. So they're just showing how little business they actually did in Nebraska. So Abdouche discovered that Lopez and KLB posted the photo of the inscription on the website and sued Lopez and KLB.
Hold it. Did it, ever exhibit in Nebraska?
Not to my understanding, no, just online, on the website.
Right. Did it have any meetings in Nebraska?
No,
In Nebraska?
no,
Did it pay sales tax? Or any kind of taxes in Nebraska?
no, they just had the 2 active members on the mailing list
That's it.
and the $614 in books that were sold in Nebraska.
Okay, perfect.
So, Abdush had discovered that KLB posted the photo of the inscription on the website and then sued them in Nebraska for invasion of privacy. Then Lopez filed a motion to dismiss, and the trial court dismissed the lawsuit based on lack of personal jurisdiction over Lopez and KLB. So Abdush appealed to the Supreme Court of Nebraska. The issue in the case that I found is, can the court exercise personal jurisdiction over the defendant if the defendant engaged in conduct purposefully directed at the forum state? And the rule that the court goes with is the effects test that we just talked about. So a defendant's tortious acts can serve as a source of personal jurisdiction only where the plaintiff makes a prima facie case showing that the defendant's acts were intentional, were uniquely or expressly aimed at the forum state and caused harm, the brunt force of which was suffered and which the defendant knew was likely to be suffered in the forum state. And so the procedural test and requirement for the effects test is that the effects test can only be satisfied if the plaintiff can point to contacts which demonstrate expressly aimed its tortious conduct at the forum state. So Lopez and KLB's of the advertisement online was directed at the entire world without directly expressing and aiming the posting at the state of Nebraska specifically.
So there you get the aiming thing. There's no aiming.
There was no aiming yet. So Abdush failed to show facts that demonstrate that Nebraska residents were targeted with the advertisements. And it's obvious, the court says anyways, it's obvious that the level of interaction with the state of Nebraska was minimal. Although the advertisement does mention that Abdush was the secretary of the Nebraska organization, advertisement didn't directly offer its sales to Nebraska. Lopez didn't know Abdush was a resident of the state of Nebraska. And the court even said that Lopez thought that Abdush had passed away, thus he had no way of knowing that the brunt of harm would be suffered in Nebraska. And the court concluded that Abdush's complaint fails to plead facts to demonstrate that Lopez and KLB have sufficient minimum contacts with the state of Nebraska. And so they they hold that the ruling of the trial court was affirmed.
Right. Very good. Excellent. Actually, in this case, not only did they use the effects case test, but they combined it with the sliding scale test. They said where there's an intentional tort, the inquiry is whether the conduct was purposefully directed at the forum state. We've seen that before. Here there was an intentional tort, invasion of privacy. There was no evidence that the defendants directed their advertisements at Nebraska. There's no evidence that defendants intended to invade plaintiff's privacy in Nebraska. Contacts here appear, the court wrote, the contacts, rather than being continuous and systematic, were random and attenuated. So it wrote, although defendant's website was highly active, none of its contacts with Nebraska were related to plaintiff's claims. That's on page 128 and 129. The good news for you is that this isn't precedent you don't have to cite this for anything because it's a state court case. And it's in Nebraska. If it was in California, yeah. But Nebraska, no. So this is just an example of how those two things can be combined, all right? It doesn't mean that they are combined. But this is one case demonstrates how both of those tests operate on internet cases, okay? So your next question is, if we get an internet case, which one should I use? What would the, huh? What?
Which test?
Yeah, which one of those two tests would you use? How about doing both, just like this case? That's a good, this is, the example of this case is it's a good CYA case. Okay, this is how you CYA. You know what I mean? You're looking at, you never did any criminal law.
No, I don't know.
You never heard about covering your,
Okay.
all right, general jurisdiction. We talked about general jurisdiction last week. Now we're going to do general jurisdiction cases. We got 3 that we're looking at. General jurisdiction is jurisdiction over a foreign defendant. Now remember, foreign defendant can mean not just someone from in a foreign country, but foreign meaning other state. If the lawsuit's in California and the defendant's in Arizona, that's a foreign defendant. Right? Okay. Jurisdiction for a foreign defendant for any and all claims, including unrelated claims and claims arising outside the forum or the U.S. That's general jurisdiction. I'm going to repeat it. General jurisdiction is jurisdiction over a foreign defendant for any and all claims, including unrelated claims and claims arising outside the foreign state or the United States. In other words, everything. The defendant will have, in order for there to be general jurisdiction, the defendant will have such substantial contacts with the forum state as to make it fair to assert jurisdiction even over claims unrelated to those contacts. That's Yezel. General jurisdiction is disfavored. Quote, because specific jurisdiction has expanded tremendously over the years. General jurisdiction, which functioned primarily to ensure that a forum was available for plaintiffs, has been rendered largely unnecessary. Thus, general jurisdiction should be disfavored. This is Fourth Circuit case in 1993, Nichols versus Searle, 1991, F. 2nd, 1195. Let's look how this applies to corporations. That is, how does general jurisdiction apply to corporations? We know about continuous and systematic. Let's talk about continuous and systematic right now. And that would be Goodyear, Dunlop versus Brown on page 133. You got
I
it?
can do it.
Who wrote
Got
this?
Ginsburg.
There you go. Another giant, although it's a very short giant. Okay? So here we go.
So,
This is a 2011 case, so we're getting pretty current. All right? Tell us about Dunlop.
so the facts of the case begin in 2004 when two teenage boys are killed in a bus accident in Paris, France. And so their parents sue, they allege that the tire was faulty. Tires were faulty in the bus. And the parents filed a suit for wrongful death in North Carolina State Court. They allege that
Where were the tires made?
they were made in Turkey, I think.
Yes.
Turkey? Yes, Turkey, had a plant in Turkey.
Yeah, so you got an accident in Paris, France, that was caused by defective tires made in Turkey.
Right. But they were made by a subsidiary of Goodyear, who did have plants in North Carolina, of course, throughout the country.
So they got sued, they sued them, they got the parents sued in North Carolina. Who did they name as defendants?
They named they made three subsidiaries in Turkey, France, and Luxembourg.
What about
They
Goodyear?
Goodyear.
Yeah. What did
And
Goodyear operate in North Carolina?
they were based in Ohio, but they did operate they did have plants in North Carolina.
Yeah. So Goodyear's not challenging jurisdiction.
Right.
The guy that subs in Turkey, France, and Luxembourg are challenging jurisdiction.
Right.
Did any of the subs do business in North Carolina?
No.
Did any of their tires reach North Carolina?
No.
A small percentage. Or a small percentage of their tires did reach.
Oh, they did? I'm sorry.
Okay, so anyway, go ahead.
So the subsidiaries were not registered to do business in North Carolina. They did not have employees or bank accounts in the state. They didn't advertise in North Carolina. They didn't solicit business, and they didn't sell or ship the tires to North Carolina customers.
Right.
So on all that basis that they really did not have minimum contacts. That's what they argued. So the trial court denied the parents' request for personal jurisdiction, and then the Court of Appeals affirmed it, and then the Supreme Court reversed it.
Which Supreme Court?
The U.S. Supreme Court.
Well, wait a minute, let's go back. What did the North Carolina Court of Appeals hold?
They affirmed the trial court's decision.
Which was?
They denied the petitioners or the parents' desire for personal jurisdiction over the subsidiaries.
They found that there was jurisdiction.
They did find that. Based on, I think it was based on the stream of commerce.
Yeah, the stream of commerce.
Based on the stream of commerce. But the Supreme Court actually found that it fell short of the continuous and systematic general business contacts necessary to empower North Carolina to entertain the suit.
What's the issue?
Oh, I'm sorry. It's whether or not you can have a foreign subsidiary be subject to personal jurisdiction.
Okay. So what did Ginsburg find in this
She
case?
found that there were not continuous and systematic contacts between the subsidiaries and North Carolina.
Did she say something about stream of commerce?
She might have. I thought she said something. I thought her argument was about the continuous and systematic.
You say so we know that it has to be continuous and systematic, but what does that mean? Does she say to what extent to be continuous and systematic? This is a big one. This is huge.
I'm looking.
It's probably as big as your house.
Is that a hint?
I don't know.
Well, I think someone says specific jurisdiction depends on an affiliation between the forum and the underlying controversy. Blah, blah, blah. Sorry, I'm just guessing here.
All right, this is huge. This is what we in the bar exam want to see. Did you see what I just wrote?
I can't see it, but
All right, it says at home. So in order for it to be continuous and systematic, it has to be such continuous and systematic contacts that the corporation is considered to be at home in that state, in the forum state. So it's not just continuous and systematic contacts.
okay.
It has to be more than just continuous and systematic. Okay?
Okay. Thank you.
No, thank you. All right. The court wrote, she wrote, a court may assert general jurisdiction over foreign sister state or foreign country corporations to hear any and all claims against them when their affiliations with the state are so continuous and systematic as to render them essentially at home in the forum state. That's on page 133. Now note, this is talking about general jurisdiction over all claims. You can have less contacts, which are still continuous and systematic, and you would have, if they're sufficient, you would have specific jurisdiction, or could, right? But in order, because general jurisdiction is disfavored, they're adding this at home thing. Okay? Does everybody have that? The stream of commerce, the court also held that the stream of commerce basis for personal jurisdiction was not enough, citing worldwide Volkswagen. Then we get to Daimler versus Bowman. Before we get there, a word about, or words about the dirty war. So you go to Argentina, the capital of which is Buenos Aires, and there's the Central Plaza in Buenos Aires consists of the equivalent of their White House, which is pink. And yeah, it's a pink house. It's the pink house. I didn't, it's the pink house, you know? And it looks very nice. And also the main cathedral of the, you know, like the National Cathedral is there, where the Archbishop of Argentina is the head of that church. That's where he does his thing. And then there's a couple of other buildings there that are government buildings. And in Buenos Aires, there are demonstrations going on every day. My wife and I were there a couple of years ago, and we walked by a demonstration. And I went up to one of the policemen who was standing there, you know, making sure everybody was keeping the peace. And I said, we asked them, what were they demonstrating about? And he said, I don't know. There's a new demonstration here every day. He said, sometimes there are 3 or 4 demonstrations. So one of the demonstrations that we did figure out was a demonstration by grandmothers of the children of the dirty war. So what's the dirty war? In the 1970s, maybe it was the 1980s. No, it was 1970s. 1976 to 1983. There was a military coup. Needless to say, it was a right-wing coup. I haven't heard of any left-wing military coups. There might have been one, I'm just not aware of it. So at that time, going back to 1945, 44, 45, Argentina had and still has a policy of pretty much accepting anybody who wants to immigrate to Argentina. Islamics or whatever. Strike that. And if they are like international, they're wanted by the International Court of Criminal Justice, or they're wanted in the countries that they're immigrating from for any kind of crime, they won't extradite them. Okay? So after World War II, you had 2 sets of immigrants that went to Argentina. Really, it was just one set. Nazis. A lot of Nazis fled to Argentina, okay, and were granted asylum. And they lived in, some of them hid, depending on who they were, and changed their names and had false passport, you know, false passports and whatever to changed their identities because they knew that they would be wanted by the Court of International Justice for war crimes, and more likely, what they feared the most was the Mossad, the Israeli Secret Service, and the Israelis who would, for lack of a better term, execute them on sight. Okay? They had assassination squads where they would take out known Nazis. One of whom was a guy who was reputedly responsible for the Holocaust, for killing the 6 million Jews. His name was Adolf Eichmann. You ever heard that name? There's a movie out right now about that and how the Israelis found him and kidnapped him and took him back to Israel for a trial. Okay? It's really a good movie. So it's entertaining, but it's also factually correct. We went to a museum in Buenos Aires that has all kinds of artifacts and explanations of how that happened, and it's accurate every way except maybe there's like one little Hollywood thing where the Nazis in Buenos Aires are chasing the Mossad, to the airport with Eichmann in the car. I don't know if that happened, but it made for a really good movie. Anyway, that kind of gives you a backdrop for what was going on in Argentina. The Dirty War consisted of the military taking control of the government, who also either consisted of former Nazis or not former Nazis were their advisors. Okay? And they arrested thousands of people. I think well over 30,000 people because they killed 30,000 people. And they tortured them. And then they killed them. And they put them in their bodies in a helicopter, and they flew them out over the ocean, and they dropped them into the ocean. So they were never seen or heard from again. The military officers adopted their children. Okay. And their mothers and grandmothers are still demonstrating in Buenos Aires for those children to be reunited with their grandmothers. All right, that's what the Dirty War was. So now, tell us about this lawsuit. Oh, by the way, Eichmann was working in the Daimler plant in Buenos Aires. That's the subject of this lawsuit. Does that give you an idea of what was going on? Okay. This is pretty hairy stuff.
Okay, so Bowman were the original plaintiffs, and they're from Argentina, and they claim that MV Argentina, which is Mercedes-Benz Argentina, collaborated with Argentinian state security forces to kidnap, detain, torture, and kill plaintiffs' relatives during the Dirty War. Daimler AG is from Germany, and it's a company that manufactures Mercedes-Benz vehicles in Germany. MB Argentina was a subsidiary which was owned by the defendants, it says the defendant's predecessor. MB Mercedes-Benz USA is an indirect subsidiary of the defendant, and it's located in Delaware, I believe. But it has multiple California-based facilities. It had a regional office in Costa Mesa, a vehicle preparation center in Carson, and a plastics center in Irvine. They also talk about how MB USA is not a defendant in the case because Daimler didn't argue that jurisdiction, so they established, so it wasn't argued that MB USA was at home in California.
Did it import what percentage of Mercedes-Benz sales were in California? Do you
It was like 2% I think.
2.4% worldwide,
Mhm.
which means a lot of Mercedes get sold in California.
And then, so what I have as issue, was does the US court have jurisdiction over a claim brought by foreign plaintiffs against a foreign defendant based on events occurring outside of the US?
Well, let's go back a minute. Did you get anything regarding how this case wound up in the Supreme Court?
Yes, so the District Court of California granted the defendant's motion to dismiss, but the Ninth Circuit reversed.
On what grounds?
They said that, it was insufficient to support the exercise of all-purpose jurisdiction over the corporation, and they declined to attribute Mercedes-Benz USA's, contacts to Daimler on the agency theory.
Did it find, yeah, this is, so. It goes to the Ninth Circuit, okay? What happened in the Ninth Circuit?
Well, they said that the agency test was satisfied and considerations of reasonableness did not bar the exercise of jurisdiction.
It said the general jurisdiction was reasonable.
Mhm.
Right. So before you go on, get this straight because it's going to come up in constitutional law. It'll come up over and over again in this case, and it's going to come up in different political issues that from time to time that you're going to hear about going forward in life. The Ninth Circuit, which is our circuit, it covers a very large geographic area and number of states. It covers California, Oregon, Washington, Wyoming, Montana. What's that other one? Arizona, Nevada, and what's the one?
Idaho?
Idaho, and Alaska, and Hawaii. Okay? It's huge. And it's considered to be the most liberal circuit court in the country. All right? After all, it's on the left coast. Right? So it reversed the trial court and used its own theory of agency to find that Daimler was an agent of Mercedes-Benz USA. Right? Okay, so tell us what did RBG write?
Well, she wrote that even if Mercedes-Benz is at home in California, there's still no basis as to subject Daimler to general jurisdiction in California because his contacts were too slim to consider it at home there. They also stated that the activities in California were, if they were to allow California to have jurisdiction, because Mercedes-Benz USA sales were throughout all the states, then all the states would have jurisdiction, and that would be an infringement on their
Due process.
their due process, because it said that it would scarcely permit the defendants to structure their primary conduct with some minimum assurance as to where that conduct will and will not render them liable to sue. They also considered, what was it?
Well, what did it say about the Ninth Circuit's agency theory? Page 140, section 8.
Criticized it, concluding that Mercedes-Benz acted as Daimler's agent for jurisdictional purposes.
Yeah, and the court must look to Daimler's contacts with California, not whether or not it's an agent. Okay? So agency doesn't cut it.
Yeah.
Did she say anything about a paradigm basis for jurisdiction for corporations? Did you see that?
Was when they talked about the European,
It's on page 140, section B, second paragraph. Everybody take a look.
for an individual, the paradigm form for the exercise of general jurisdiction is the individual's domicile. For a corporation, it is an equivalent place, one in which the corporation is fairly regarded as home.
Right, so this is the current iteration of the rule and the application of the rule by the Supreme Court of the United States. And notice who wrote this opinion. She's still there. Okay? No one can say or accuse her of writing a left-wing opinion on this case. Would you agree? I mean, this is clearly in favor of the corporation and against the plaintiffs. Right? And put it another way, the Supreme Court doesn't like general jurisdiction. Get it?
Yeah.
So you got to show for a corporation that it's at home in the state, and it goes on. Thank you. Good job. It says, she says on page 140, section B, second paragraph. What does it mean to be at home? It's the place of incorporation or the principal place of incorporation. All right? I don't know if I got that right. Did I get that right? I think I missed
Place of corporation, principal place of business. Is that
principal place of business. Yeah, I don't know. I must have been. Must have been artificially enhanced when I did type that. Okay, it's a principal place of business. Okay, so what you're looking at on an exam when there's an issue like this, an attempt to assert personal jurisdiction over a corporation and assert general jurisdiction, that's going to be like against a foreign corporation, like from a foreign country. Or it could be a lawsuit in Oregon against a large corporation that's incorporated in Delaware and has its principal place of business in Oregon. Right? So for purposes of general and personal jurisdiction on a corporation, it can be either of those or both. Okay? So let's say the lawsuit's in Oregon and they're incorporated in Oregon. You got it. If it's a Delaware corporation, but it has its, what do we want to say for principal place of business? What's the principal place of business? Well, for sure, it's probably where they have their headquarters. So if their headquarters is in Oregon and they're a Delaware corporation, that's enough. They're an owner. Okay? And remember, what is it for a person? We did this the first week. Domicile. And what's domicile? Huh? It's an intent, right? An intent to permanently reside. Remember? So let's take a look at Burnham versus Brown on page 143, 1990. This one comes up all the time. So the plaintiff is Mrs. Brown. And the defendant is her husband. They were married in West Virginia. They moved to New Jersey. They agreed to separate. The plaintiff, the wife, would move to California. And it was agreed she would file for divorce in California. The defendant husband, being a stand-up dude, filed for divorce in New Jersey before the plaintiff could file in California. Now we know why she wanted a divorce. But although he filed in New Jersey, he didn't obtain a summons, and therefore she was never served. She filed for divorce in California afterwards. And he went to California on business after she had filed her lawsuit. And after he was done with his business, which I think it was in Los Angeles, he went up to San Francisco, or the Bay Area, to visit his kid. And when he came to the door to get the kid, she served him. Okay? He challenged jurisdiction. Oops. Okay. I turned it off. I'm sorry. So the issue is, does due process require a connection between the litigation and the defendant's contacts with the state in cases where the defendant is physically present in the state at the time process is served? And the answer is no. Page 145, first paragraph. This is an opinion written by Scalia and 3 justices. That's 4. Okay, is that a majority? 4 out of 9. Okay? This is not a majority opinion. But Brennan, another, I said he was a giant. I can't say that Scalia is a giant yet, but I think he probably will be considered one. Brennan and 3 justices concurred. So they came to the same result for different reasons. Okay? So this can be considered precedent. A rule is good law, right? Scalia writes, physical presence alone constitutes due process because it is one of the continuing traditions of our legal system that define the due process standard of traditional notions of fair play and substantial justice. He writes that on page 140. Why is physical presence one of the continuing traditions of our legal system? He says, because it's always been there. Okay? Scalia was what is called an originalist. Have you heard that? You understand what an originalist is? An originalist believes that the Constitution and statutes should be interpreted as written by the founding fathers in 1789 and 1791. Okay. With respect to statutes, it's as the statutes were written by Congress whenever they were written, and if there's an issue about whether they conform with the Constitution, then to compare that statute with the intent of the founding fathers. Okay? Now, how do you find out what the founding fathers intended? Well, there's the Federalist Papers. A lot of judges they read the Federalist Papers to see what the founding fathers wrote. If that doesn't work, then they conduct a seance. You know what a seance is? You don't know what a seance is? Okay. Okay. Say, do you have any relatives that died? And you'd like to say goodbye, or you'd like to find out what's going on with them, right? So you go to this gypsy lady, right? And they conduct seances. You all, everybody in the family sits there and they hold hands, right? And then she does some stuff. And lo and behold, she's talking to your relative. Well, so, if they can't get it out of the Federalist Papers or whatever else is there, then they go to this gypsy lady.
They summon the founding fathers.
Right, there you go. Right, so that's an originalist, all right?
Is that gonna be on the test?
So remember, there was this case we read about, Schaefer versus Heitner. Okay, so wait a second. I mean, Schaefer versus Heitner seems to be, what are you looking at? Schaefer versus Heitner? Yeah, what did it say?
Well, it says that Schaefer compels the conclusion that a state lacks jurisdiction over an individual unless the litigation arises out of his activities in the state. So it's going back to the minimum context
Yeah.
argument.
Yeah, so Scalia says, what? Schaefer versus Heitner. Schaefer stands for nothing more than the proposition that when the minimum contact that is a substitute for physical presence consists of property ownership, it must, like other minimum contacts, be related to the litigation. That's on page 141, section D, paragraph 2. Is that where you are?
146.
Okay. Didn't think so. All right, so he basically is saying, oh, Schaefer versus Leitner doesn't matter. Okay? We're disregarding that. He says, here the defendant was present when served. Therefore, the court need not look to minimum contacts. What you got there?
I was looking at our analysis,
Huh?
the analysis
Yeah, the size of the analysis.
for this case,
Who's that?
for this case.
We're looking at our comparing analysis is,
Whose analysis?
The courts for this case.
Whose analysis are you looking at there?
Oh, our analysis.
Your own analysis?
Yeah.
yeah,
Okay.
the Schaefer versus.
You can
Heitner.
tell me about this in a minute. Tell me what you got, but first let me get to where I'm going. Okay, so Brennan and the 3 justices that joined with him in concurring said, unlike Scalia, he would undertake an independent inquiry into the fairness of the prevailing in-state service rule. The fact that American courts have announced the rule for perhaps a century provides a defendant voluntarily present in a particular state today clear notice that he is subject to suit in the forum. The transient rule is the transient rule, this is the rule. Transient means you go into a state transiently, just for a few minutes, or maybe 30 minutes, or an hour, and you're out. Okay? The transient rule is consistent with reasonable expectations and is entitled to a strong presumption that comports with due process. So they're not saying anything about Schaefer versus Heitner being limited to property. Okay? So the fact that Scalia and 3 justices joined them means that the analysis with respect to Schaefer versus Heitner is dictum. Because only 4 justices agree with that, and 4 justices didn't agree with it. Okay? But what does this all stand for? It's what we refer to today as tag jurisdiction. As in, tag, you're in. You wind up in a state, and the process server knows you're going to be there for even a short period of time, and he catches you, and he gives you the subpoena, or the summons. You got jurisdiction. He was in state when he got served. That's all you have to show. Okay? So just remember tag jurisdiction. All this other stuff is interesting. But since this is what's called a plurality decision, what it stands for is tag jurisdiction is effective and establishes personal jurisdiction. Sometimes you'll see a fact pattern that a guy flies in to California, flies into LAX, and while he's in LAX waiting to get on a plane to the Philippines, a plaintiff serves him. or he's at a seminar in the Bay Area, and at lunch he gets served. Okay? Yep. Got it? That's tag jurisdiction, tag, you're it. It doesn't matter. You can state it any way you want in terms of, you can do it, but basically, what I would do is I would just say, this is a plurality decision that stated that if the defendant is present in the state when he's served, then that satisfies due process, and you have personal jurisdiction. Okay? Make sure that you read, wait a minute. So guys, what was your analysis?
It was this basically the
I
same
mean, the
thing.
same,
No, come on, show and tell.
we were talking about the Schaefer versus Heitner, and, she omitted that from her brief where I included it, and I just said.
What did you have in your brief?
Me?
Yeah.
I said Dennis cannot rely on the holding of Schaefer versus Heitner, which held that a state lacks jurisdiction over an individual unless the lawsuit arises out of the activities in the state. This doesn't apply to Dennis because the non-resident was an absent one and was not served personally, unlike in this case where he was served personally.
Yeah, okay. And you didn't have that?
No.
All right. You're forgiven. But the point is, it doesn't matter because
It was kicked.
it's a plurality decision, so neither side's analysis is precedent. What's precedent is the result. Okay? Are you guys starting to kind of get a handle on constitutional law?
I have a question.
Yeah,
There's 9 justices, right?
right.
Okay, so there
No,
was.
right now there are 8.
But at the time it was 9.
Right.
I don't know. So there was 4 one way and 4. So is the other one, are they required to make?
It may have been at a time when there wasn't a 9th justice like
Oh,
now,
I see, okay.
okay? If Kavanaugh isn't approved before, I think it's the second Tuesday in October, when the Supreme Court starts its term, they'll do it with 8 justices. All right, until there's a new justice.
How would they come?
Life goes on.
How would they do a tiebreaker in that?
What?
Like, let's say they hear a case and there's only 8 justices, how would they decide?
I do it the same way they do with 9. I mean, they all sit in the bank, and the Chief Justice usually is like the moderator, and then he'll say the appellant gets up first and begins to make their argument, their oral argument, and the justices interrupt and they ask them questions. So instead of 9 justices asking questions, it'll be 8. In actuality, in the past, when there were 9 justices since 1991, was it 92? There are only 8 justices have asked questions because Thomas doesn't ask questions. He doesn't say anything. Okay, so Thomas just sits there. So 8 justices in the past have asked questions, so now it'll be 7. Now, I can assure you, when you're in an oral argument, if it's 3 or 7, it's equally unnerving. Okay? And sometimes it isn't. Sometimes it's amusing. I was arguing a case in the 9th Circuit in San Francisco, And it's a three judge panel. And one of the justices asked me a question out of left field that had nothing to do with the issues. She was asking me a practical practice point, which was, well, since this one defendant witness had died, how am I gonna deal with that at trial? How am I gonna, and I had videotaped his death. And I looked up at the presiding justice and he went, and I just sat there for a minute and I said, I videotaped his deposition. And the justice who asked the question went, oh. And then we went on arguing. I mean, it can be that kind of stuff. You absolutely have no idea what they're gonna say or do. They can ask great, really uncomfortable questions about, your position, or they can ask you what's the sky like out there tonight. Okay. All right. So we almost made it to 9 o'clock. All right, Trish, you okay?
I'm good. Thank you.
Okay. We're done.
Have a good one.
You too.
Thank you.
You're welcome. Oh, before you leave, would somebody, can I get a list of your emails? Does somebody know what
Yeah.
What?
have it.
Trish, would you? Because I'll be, I'm gonna wanna send you guys stuff. I will not tell you what yet. It's gonna be a surprise.
You know what Trish's is?
It's Trisha's